Now that we are talking about the Supreme Court and the courts, there are two cases related to mining and environmental law which would be critical to even examine all this, the legal framework that we've been discussing so far. And these two cases are of different nature. One where the court has taken action in a specific, we came much later to take an action in a specific mining operation in Odisha. The other relates to, and the first one relates to only one particular project. The other relates to a far-reaching policy change when it comes to sand mining in this country. So let's look at the first case. The first case actually talks about bauxite. It's a very famous case related to bauxite mining in the Niyamgiri hills of Odisha, in the eastern state of Odisha. Till 2004, the Niyamgiri hills spreading across Rayagada and Kalahandi districts of Odisha were known to a few. This changed when Sterlite Industries, part of the international London Stock Exchange registered entity Vedanta, and the Odisha Mining Corporation disclosed their plans to mine bauxite here. Subsequently, 3 sets of cases were filed before the Supreme Court Central Empowered Committee, which was set up as part of the ongoing Godavarman case, which we just discussed in the previous slides. These cases actually highlighted a range of impacts that included those on the lives of the Dongriya Kon tribal communities, for whom the hills are sacred, on forest produce, wildlife, sources of water which are emanating from these hills. One of the key legal issues from the very beginning of this legal battle was that Sterlite had initiated construction of the refinery, which was linked to the mine, without approval for the mining component. So they basically decided, it was a single project, but decided to break up and start construction on one component of the project without taking the forest approval for the mining. And this was integral to the project's viability. And it was mentioned in the Environment Impact Assessment Report. The total mining lease area of this project was 721 hectares, but out of this 660 hectares was forest land in the sacred Niyamgiri hills. And that's why it required approval for forest diversion for non-forest use under the Forest Conservation Act. Sterlite and the Odisha Mining Corporations, over a period of time when this matter was being litigated, linked and delinked the mining component several times over, just to ensure that their refinery goes on functional. There are links to various additional reading and articles related to how this really transpired in the text of the module, which you will read. In November 2007, actually something interesting happened. 4 years after the case was filed, or the cases were filed, the Supreme Court suggested that the mining could take place provided there is a special purpose vehicle that was set up by Sterlite and Odisha Mining Corporation. So they actually said Vedanta cannot mine, but the Vedanta subsidiary Sterlite can mine as long as they enter into a special purpose vehicle with the Odisha Mining Corporation. The Ministry of Environment, Forest and Climate Change subsequently rejected the proposal for carrying out the mining on 24th August 2010, and in between there were committees that were set up, there were interim other orders of the Supreme Court, which are again detailed in the text of this module, and additional links that have been provided along with it. And they basically said there were several reasons why this mining should not take place, also because it also violates the recognition of forest rights under another law that had emerged from the Ministry of Tribal Affairs. Sterlite and its parent company was not happy. They challenged this in the Supreme Court, and on 18th April 2013, a landmark decision which vested the future of bauxite mining in the hands of all the village councils, which are the Gram Sabhas, not the village councils, but the village assemblies, which are the Gram Sabhas in Niyamgiri. Almost 12 such Gram Sabhas were held under the supervision of the Ministry of Tribal Affairs, and all of them unanimously rejected the proposal. Following this, the ministry also issued a particular order rejecting the forest diversion for mining in Niyamgiri hills. So this case, reading more details about in this case in many more details, you'll realize all the issues related to EIAs, forest diversions, as well as impacts on wildlife get juxtaposed in this particular and enthralling case, which you could read through the links provided in part of this module. The other case is relatively more straightforward, although it's had huge implications on riverbed sand mining taking place in the country. On 5th August 2013, the National Green Tribunal, based in Delhi, passed a strong interim order which restrained removal of sand from riverbeds across the country unless requisite approvals by the Ministry of Environment, Forest and concerned state impact assessment authorities had not been procured. Again, MOEF and SIA are required to give separately process approvals for Category A or Category B sand mines. This had been a mandatory requirement following actually what the NGT was doing was reiterating a Supreme Court's judgment of February 2012, which amongst other things had really clearly said that environmental approvals under the EIA notification are needed for all sand mining projects and all activities even under 5 hectares, which we had clearly referred to when we were discussing the EIA notification and its procedures. This judgment in Deepak Kumar versus State of Haryana and others had also made critical observations related to environmental impacts of sand mining before issuing these directions. Again, there are links provided in the text of this module which will give you additional information and reading on this particular case and the judgment. The NGT's follow-up order of 14th August 2013 reinstated this fact and took forward the non-compliance of the February 2012 order and judgment of the Supreme Court. The NGT order first acknowledges that there is rampant illegal sand mining that has continued despite the directions of the higher judiciary, and directs all state governments in India to respond to the 7 issues that they raised as part of this order. Since the time of the directions were first issued, the state governments have been submitting information to the NGT and what steps should be taken to implement the order. And this case is currently ongoing and is awaiting the final conclusion and judgment from the Green Tribunal. This module also leads you. Basically we are almost at the fag end of the module, but this module also gives you insights into and leads into 2 very critical and interesting processes which have shaped the mining sector in India to a large extent over the last 3 or 4 years. The first is the M.B. Shah Commission and Inquiry into Iron Ore Mining in India, and they have given state-specific as well as national overarching reports on iron ore mining. Based on this report, additional inquiry commissions, including the Central Empowered Committee, has been looking at iron ore mining and all the illegalities related to allocation as well as environmental and forest clearance issues under which their non-compliance has been high. In fact, based on this M.B. Shah Commission report, iron ore mining in Goa, in the state of Goa, had actually been banned for a very long time. So actually delving deeper into this, the M.B. Shah Commission and how it was used in the Supreme Court and what implications it had would be very important additional reading to locate environmental law in the socio-political context in the country. The other case, which is again very significant and is reshaping the coal sector and the coal block allocations in the country, is the Supreme Court case on coal mining allocations. August and September of 2014, there were clear directions and judgments issued by the Supreme Court which actually cancelled the allocation of 218 coal blocks which had been allocated since 1993. So, as part of this module, what have you really looked at? If you need to summarize the whole module, what have you really tried to address in this module? And I would request you to read the module in detail and understand it 2 or 3 times before, because the legal overlaps can be a little confusing. So what have we looked at? The mining sector in India is regulated by a range of laws, and we are only dealing with the environmental laws here. I'm not even dealing with the pollution related laws, environmental impact assessment, forest diversion approvals and wildlife related approvals. So each time, and this is important because each time land is to be converted for mining, there are a wide range of ecological and social implications of such land use change. What this module has dealt with are 3 regulatory frameworks which lay out procedures and safeguards that mining agencies would need to follow prior to initiating operations. These are quote-unquote environmental clearance under the Environment Impact Assessment Notification 2006, forest diversion related approvals under the Forest Conservation Act 1980, and approval for the use of protected areas for wildlife under the Wildlife Protection Act of 1972, amended in 2002. Following a description of procedures and recent changes and implications of these laws, what this module also tries to do is it locates the application of these laws in two landmark cases related to bauxite mining in Niyamgiri Hills and the restriction of sand mining, especially the riverbed sand mining across the country. It finally gives a glimpse into two significant legal and policy processes that have had a significant bearing on regulating iron ore and coal mining sectors in India. I wish you all the best and with the assessment and the learnings of this module. Thank you.